started.
Thank you. Good evening, everyone. My name is Amin Johar, and on behalf of the Center for Applied Law and Technology Research at Vidhi, I welcome you all to this virtual roundtable. The tabling of the JPC report in December marks an important milestone in India's journey to enact its standalone data protection statute. Vidhi has been at the forefront of the privacy discourse in India for the past 5 years, starting with our seminal research work in January 2017, where we recommended how a holistic data protection regime could be formulated for India, preceding the Supreme Court's ruling in Puttaswamy. Following the court's judgment, Dr. Orgo Singh Gupta was invited to be a member of the Sri Krishna Committee, and he, along with research fellows at Vidhi, assisted in the drafting of the original PDP bill. Since then, we've been aiming to constantly shape the discourse on different facets of data governance, which culminated in our report on data stewardship models for non-personal data in November of 2020. And today's session is yet another step to actively engage with this resurgent discussion around data protection and the PDP bill. With this, I hand it over to Orgo, who will be moderating today's roundtable. Orgo?
Thanks very much, Amin. Good evening, everyone. We've got a very packed agenda, so I'm going to dive right in. But before I do that, I was just seeing the attendees list, and I'm delighted to have so many attendees, and particularly Justice Sri Krishna. I saw his name on the list. Thank you very much, sir, for joining us. You really started this journey, and we are here today because of you. So the data protection bill will undoubtedly affect the lives of citizens, businesses, and governments. But the key question is how. So we'll be discussing two issues today during the course of this 1-hour roundtable. What are some of the key features of the data protection bill that require closer looking at before they become law? And second, how can this bill be taken ahead so that it can become the law of the land? A super abbreviated round of introductions first before I jump straight in. We've got a great panel. Vyom Upadhyay is head of data sciences and analytics group of the ICICI Bank. Vrinda Bhandari is an advocate in the Supreme Court and a technology lawyer. Shubhashish Banerjee is professor of computer science and engineering of IIT Delhi. Malvika Raghavan is currently a doctoral candidate at the London School of Economics. In her past life, a lawyer and a policy wonk. We also have Shupratim Chakraborty, who's a partner at Khaitan & Co., specializing in data protection law. Matthias Goods, who's a partner at Nicol Goods and a GDPR law expert. Trishi Goyal is a fellow at the Vidhi Center for Legal Policy and lead author on a referencer on the JPC report that Amin just mentioned. And we hope to have Rahul Mathan, who's a founding partner of Trilegal. Unfortunately, his family has been hit by COVID just yesterday. So he may not be able to join us, but I do hope that he joins us soon. So for all those who are interested, Vidhi's referencer on the JPC report, which dissects some key elements of the JPC's findings on the data protection bill, has just been posted in the chat box by Amin in case anyone refers to it. So the format for today will be taking quick opening remarks on some specific subjects in about 2 to 3 minutes from everybody. And then we'll do a moderated discussion for about half an hour. For everyone in the audience, please feel free to type your questions in the chat box. I'll keep taking your questions in the chat box as and when the opportunity arises. So let's get going. And I think it would be interesting, Vyom, if we could start with you. On the topic of businesses and data protection, how do we make this operational? Over to you, Vyom.
Hey, thanks, Argo, and very good evening to all of you. First of all, thanks for having me on this panel. As with so much of legal talent on this expertise on this panel, I'm very much here to learn on this subject as well. But I want to share my thoughts as a practitioner in the area of data science, data processing, as to how we can, what kind of things we can do to make the framework operational, to make it work for the customer. So one thing I can say is that in financial services, at least, driven by RBI, a very progressive regulator, BCSBI guidelines and concepts like do not call, etc., have been in place for quite some time. And then, of course, we had the NDNC, the registry, which came in, which to my mind was the first control which the Indian customers got on how their data is processed. And of course, as we go along, as we operationalize the framework, there'll be lots of other areas, apart from financial services or telecom related, which will get regulated, and hence all of this will lead to a lot of benefits for individuals, and there'll be a lot of course catch up to do before it becomes operational. But I think all around a lot of benefit for the individuals is what we can see. But two things I want to pick up. One is, of course, as we think about making it operational, we need to sort of detail out what does personal data mean. And here, for example, if I take an example of a bank statement, it's easy to imagine that there's a lot of personal data on that statement. There's a PAN number, there's a name, there's an address, etc. Right? But then, as we think about financial data, there'll be some data which is, let's say, the interest that the bank has levied on that loan, or interest that the bank has credited into the account, right? So there are some parts of that statement, which are specific to a two-party contract, which are specific to what resulted out of that transaction between the bank or the financial institution and the customer. And so it's a mix of, so even if you take a simple example like a statement, it's a mix of various types of data elements, some private data, some as a result of these contracts. And of course, as we add non-personal data to this, we come to the area of overall information security, which of course is a huge area, and of course we need to detail that out further. So as India's PDP is the first significant privacy law which counts financial data as personal. So we'll go from here to a successful rollout. We'll of course have to do a lot of detailing, and very happy to engage further and support with the same. Second part is really on the consent taking. So free and fair consent is a must, and we are having this discussion in the backdrop of 90% of Indians being vaccinated, which is in a setup which is completely voluntary and consent based. So which is such a huge if there's 3 cheers to the overall vaccination program, at least 1 cheer for the part of consent as well. But having said that, there are some things that we need to guard against, which is sometimes the claims which are being made to take consent, let's say something is free or even comes with a cashback, etc. So sometimes customers, what kind of data they're parting with is not really explained, or it's not really very clear to the customer when they're giving that consent. So all of this needs to be guarded against, and so we need to create enablers and a framework where type of consent, what are you giving away, becomes very, very clear and very, very simple, understandable by the customers in very simple terms. So I think these are 2 points which I wanted to make in the opening comments. One is, of course, classifying the data in more detail, and secondly, creating a consent mechanism which is very informed and fair.
I think that's great. I think that's a very useful perspective as to how do we make consent operational. And I think it's one of the things that the JPC also refers to. So I'll turn next to Supratim Chakraborty to provide us an overview of the JPC's recommendations and what he thinks are the critical recommendations, and also touch on this issue of non-personal data being brought in to the data protection bill. Supratim, 3 minutes.
Right. Thank you so much. And I'll try and keep this snappy. Of course, a number of recommendations. The key ones, I think the first one, of course, is the timeline for implementation, which now is 24 months. To my mind, this is a welcome move. We have a concrete, number now put there, and something which is akin to a global standard. The next one is, a common framework for personal and non-personal data. And towards the end of this minute or so, I'll just dive deeper into the non-personal data related element. The third one is data localization. Again, there's a lot more emphasis on localization, and you can see that how perhaps data nationalism is playing large in the mind of the authorities. Next is amplifying the regulation to say, digital media, social media intermediaries being included. You also have new mechanisms for certification of digital and IoT devices. So it's gone beyond the software part of it to devices. Next is crystallization of certain norms in relation to data breaches. Now, this is something that we have been following for some time, that in relation to data breach, the government has become a little more sensitive, and there is a little more meat and crystallization, as I would say, which has been brought in. Processing of children's data finds a little more or prominent mention and refinement. There are aspects in relation to processing of employees' data, which has been made a little more pro-employee and employee. And I would say, if you look at the overall scheme of things, the tilt has been brought a little more towards data principles, and therefore some flexibility which was available to data fiduciaries has been taken away. We'll delve deeper as we discussed during the session. The last few is the data protection officer. Who can those be? I think that's an important development. And flexible penalties. Okay, so that's the total overview. Now let's come to non-personal data. Okay, Justice Sri Krishna committee, when they deliberated, they left it saying that there should be another committee which should be formulated, and they should look into it. Interestingly, after Justice Sri Krishna handed this over to MeitY, they wrote to a few people. I was one of them. Some questions. 3 of those questions I remember, I think, were in relation to non-personal data. So it was playing for some time in their mind, perhaps. The question for us to be answered is this the right time? As a society, as a country, have we matured enough to reach that stage to have non-personal data included in this legislation? More importantly, Orgo, I don't know whether we have a precedent of this nature where you create a half legislation and create some avenue for non-personal data, which will subsequently come and fit into the scheme of things. Okay. Now, 3 cardinal issues which have been pointed out by the committee, which says, why are we doing this? Because non-personal data can also affect privacy, and they have not really given too much of a justification for that. The second thing is they've said it is difficult to distinguish between personal and non-personal data. I'll club both these and just answer. Perhaps it's available in the non-personal data governance framework, which has already been formulated. And the way they are dealing with it, they're saying that if there are mixed data sets, which are inextricably linked with each other, then let PDP Bill handle it. If there is a personally identifiable data, including anonymized data or subsequently re-identified data, let PDP Bill handle that. And if there is anonymized data that at the time of evaluation has not been re-identified, let that be dealt with by non-personal data framework. Okay, it's a very black and white situation to my mind. There's nothing to get confused about. And the next point that the committee is stating is that different data protection authorities to deal with 2 different data kinds should be avoided. Now, let's make a distinction here, okay? There is no harm in having 2 different laws, but 1 single regulator. So perhaps we can come to a middle ground that it's fine to have perhaps 1 regulator, though I think it's a omnibus regulator, which will have a lot to deal with. But the point is that we can have a single regulator dealing with 2 different legislations prepared at 2 different points in time. Personal data, which is already baked right now, ready for us to really have floated. And the second one, non-personal data, which is further deliberated, looked into, and legislated, and then we bring into the fold. I'll stop there, Argo.
Thanks very much, Supratim. I think there's a lot to discuss on that non-personal data issue, including this idea of a half legislation. I'll turn now to Vrinda. Vrinda, you've been following work on surveillance and particularly how the data protection bill has gone through many changes as far as the question of surveillance is concerned. So your 3 minutes on the question on the data protection law and surveillance, particularly by governments.
Yeah, thanks a lot, Orgo. So I think I'd like to use the 3 minutes to basically make 3 points. The first being, even originally, I think the data protection bill, it did represent a missed opportunity for surveillance reform. Like India, historically, we've had 1 surveillance legislation that seems to cover everything. It's not necessarily, the constitutionality of that surveillance regime has been challenged. I think the data protection regime could have played a very important role in trying to put in place principles that would then help regulate mass surveillance projects that we are seeing right now, such as the, the CCTNS system or the NAT grid or the central monitoring system. So I think, although the Justice Sri Krishna Committee report actually mentions in the report itself, there is a lot of, sort of talk about surveillance, and in fact, the importance of inter-branch oversight, the importance of judicial oversight of surveillance reform. I think the bill itself and the bill that has now come out does represent a missed opportunity. This is particularly important in India for two reasons. One, the Aadhaar judgment, and at least my reading of the Aadhaar judgment, and I should point out that not everybody reads it necessarily the same way, but I do believe that the Aadhaar judgment did lead the step forward to say, yes, you should have some judicial oversight when you're talking about surveillance and intelligence collection. It is also something, as the Sri Krishna Committee report itself points out, is at odds. The lack of inter-branch oversight is at odds with what is happening in democratic countries across the world. And the second reason is India, unlike most other countries, does not really regulate its intelligence agencies. There is no parliamentary accountability, much less any judicial accountability over, the way the IB works, the RAW works. So I think given that, it was very important to have done something on surveillance reform. And also given that after a long time, India is actually going to be coming up with a law on data protection. So this should have been the right opportunity. But even looking at what we have, I do feel that the government has actually more, and the JP goes forward in increasing the powers of government surveillance and all the other exemptions. And there are two sections in particular that I would like to talk about. The first is section 35, which is perhaps what has gotten a lot more media attention, because of a blanket exemption that it gives government agencies from the application of any or every provision of the Act. So even things like security safeguards. So a government agency, if it is necessary or expedient, and expedient just means convenience in legal language. So if it is expedient in the interest of national security or public order, can effectively exempt the application of the entire Act. And they don't even have to comply with simple principles like security safeguards. So the fact that they have my data, how are they treating that data? And I think that's obviously problematic. The JPC does try and this is especially important, I think, because the Justice Sri Krishna Committee report at least had tethered this exemption to the conditions of legality, necessity, proportionality. Like you could see the impact of Puttaswamy on these judgments. And I think it matters when the reference goes away, because on a practical implementation to then go and argue that no, Puttaswamy still requires you to apply proportionality becomes much harder. I think the law could have made it simpler. And I think the JPC does try and make some improvement when they say, oh, the procedure that should be followed by the government must be fair, reasonable, and proportionate. And this is something I'm happy to get into in the comments. But the change is only applicable to the procedure and not the substantive standard for the government's invocation of exemption. And this is important. So simply, the government does not need to establish that the exemption from the DPE, the Data Protection Bill, is necessary to achieve its national security interest, right? And the third, and I think actually the most insidious of the provisions, which hasn't received as much attention, is section 36, because this is something that is going to apply to all of us and is actually going to affect most of us in our daily lives, because it exempts any individual, not just governments. Section clause 36 does not have any exemption that applies only to government. It applies even to your RWA. And we've all seen the role RWAs have taken up during the COVID pandemic, CCTV surveillance becoming popular. So I think this is very important because it allows the exemption of effectively, again, most of the Act, except security safeguards, if it is in the interest of prevention, detection, investigation, or prosecution of any offense, which will mean even like a check bouncing case technically, or the contravention of any law for the time being enforced. And I think the way this will interact with your local police or your local RW is actually something that we will all experience. And I actually think that is more, in a way, dangerous. So I think for right now, I'll stop with these 3 points.
Thanks very much, Vrinda. I think it's good you pointed out section 36, because that's something that's often missed. And I see Rahul's also joined despite the difficulties that he's been facing. Thanks very much, Rahul, for making the time to join us. We've just started and I'll just come to you very, very shortly. Now let's turn over to Shubhashish. Shubhashish is a computer science expert, so will provide a different perspective, particularly on this question on how can we design for privacy, because this is a concept that's been there in the data protection bill from the Sri Krishna Committee's time, that we need privacy by design. So how can we design for privacy and how can we ensure self-regulation as a method of data protection? 3 minutes, Subhashish.
Thanks, Argo. So thanks for having me on the panel. So I'm a bit nervous to be surrounded by lawyers and being a computer science academic. I'm sort of like a fish out of water. So I won't, try to discuss solutions, but I'll raise some concerns, that I see in the PDP bill and also in the JPC report. The first one is consent, perhaps. There's an over-reliance on consent that I see there. And it sort of underemphasizes that a data controller should be accountable for privacy protection, irrespective of the level of consent. So this maybe gives an opportunity to a data controller to hide behind consent in some way. And that needs to be addressed, especially in large public service applications. The second problematic issue that I see is anonymization. And it defines as anonymization as a irreversible process. But it fails to underline that it'll almost always be a vacuous set, right? So if I battle between anonymization and the de-anonymization, the number of time anonymization will succeed will be close to zero. And there's a theorem to that effect. So given that context, that this is almost a vacuous set, this whole business has to be, in my opinion, reworked. Right now, there's an interesting debate going on about US Census 2011, which is completely de-anonymized. So they're protected using differential privacy in 2021. And there is a paper by Kenny that shows that also is almost totally de-anonymized. So that discussion is going around as we speak. The third concern, and is the most important concern that I've always had, is a little bit of what is the level of due diligence that is necessary for a privacy protection standard? So when you talk about purpose limitation, transparency, risk modeling, what is the level of due diligence that is adequate? Who defines the standard? So if my reading of the PDP bill is correct, then the DPA will specify all this in some kind of a subsidiary regulation. But even then, what is the guiding principle behind it? So when do we know that the privacy standards have been met? Or what are the privacy standards that we have to achieve? So if this is not clearly specified, what I foresee is that there will be a wide variety of, or a wide gap in different possible interpretations. So different DPA will come up with different things. And in such a case, purpose limitation will be almost impossible to ascertain. So, somebody will say, I have done privacy by design, by forceful proclamation, and somebody will say, no, you haven't, and what is the way to resolve this? So that standard, where should it come? Can it come with a subsidiary regulations, or there should be guiding principles in the DPA that needs to be addressed? I also find that the exemption clauses are too broad. In general, I think Vrinda has spoken on it, so I won't delve into it, but I think that this is just too broad, the entire section. And finally, the social media, that's a different beast altogether. That's a both in terms of utility and risk, it's a completely different thing. And the due diligence that has gone into the DPA bill, I think, is grossly inadequate to say this way or that way about the social media thing, and it requires a completely different level of investigation, in my opinion. So I'll stop here. And,
Thanks very much, Subhashish. I think that's a very, very interesting perspective. And particularly on the DPA, I think it provides a great segue to get Malvika Raghavan in, who's been working right from the time of the Sri Krishna Committee and before on the DPA's effectiveness and independence. So how are we going to exactly enforce this, Malvika, and your thoughts on that, on the DPA?
Thanks, Argo. And in my 3 minutes, I suppose I'll just try and provide a headline diagnosis on the health of the DPA in this structure, in this current structure, and how it's changed, and perhaps how that affects enforcement both within and outside government. I think that's the important thing to think about. What is the role of this organization within government, which is often a champion for data protection within government. So as a doctor, as I'll start off by saying there's a good news and bad news. The good news is that we have a DPA, and many of you know that when we started this journey, that was not a given, right? There was really self-regulation was the chosen approach. So at least we've come so far, we have a DPA. I think the bad news is that it might be struggling for oxygen. I sincerely hope not, but I think essentially there are 3 or 4 structural elements of the DPA in terms of institutional design that haven't changed since the last iteration of the bill. And I think just in a couple of ways, they actually have been weakened. So many of you, again, have been following this, so you will know it. The first thing is that in terms of the institutional structure, it's got a very small board, and that board has only whole-time members. And the number of the board is limited to only 6 whole-time members. That remains the case, despite many people saying it should be wider. It could be a very large authority. It should have external experts and so on. And interestingly, the selection committee as well, which was originally, I think the demand to expand inclusiveness of the DPA accountability mechanisms and board has been tried to be solved through the selection committee, where new people have been added. This is the committee that selects who gets to be the DPA. Now you have a few additional non-government employee people on that selection committee, a director of an IIT, a director of an IIM, and an independent expert. However, I think the question though is, ultimately, we are still looking at a very centralized, very small DPA sitting out of Delhi for a very, very large country. Selected from fairly, it looks like a very government bureaucracy oriented constitution. That's not in itself a bad thing. As we know, most regulatory experience comes from prior bureaucrats. I think there is many of our regulatory agencies are staffed that way. I think the concern here is what impact will it have on the powers and functions? And to that, what I want to talk about is, if that is your institutional structure and design, you're looking at your responsibility and your respect. I'm just checking that you can all hear me. Okay, I think my internet connection is a little bit unstable. Thank you. So when we look at this institutional structure, I think there are basically 2 points at which it might impact the functioning of the DPA internally and externally. Externally, what I mean is that when you have such a small body, and I should mention that appellate tribunal as well. So this DPA not only has a board, it also has a separate appellate tribunal because it does quasi-judicial functions. It takes complaints, it adjudicates and enforces matters when companies aren't following privacy standards. Even there's been a change to make it only 6 appellate tribunal members apart from the chairperson. So this means you have a very small body looking at an immensely huge country at every level, plus a larger mandate of non-personal data as well. So not only do you have all the existing 5 or 6 mandates, you also have a large mandate, but a smaller set of people taking responsibility. I think internally why that will that might affect this DPA is that one of the we don't talk about, again, section 36 point that Brinda brought up, I think one thing that we the powers and
Malvika, you might want to.
We don't talk enforcement. Person,
we can hear you now, but you might want to switch your video off.
Sorry. And I think honestly, that was the final point I wanted to make, which was just around the fact that the DPA both has immense responsibilities, but on one level, it also has extremely constrained resources from what we can see. And the other thing is, of course, the constraint in the resources and the kind of internal staffing, as it were, might also reduce its credibility within government or ability to assert and leverage external resources in a room where there will be some very difficult decisions to be made by several different counterparts of government. But I can go into all of this in more detail, and sorry about the connection. Thank you.
No. Thanks very much, Malvika, for joining. And I think one of the key functions of the DPA will be to determine who is a significant data fiduciary, because in the Act, there's a lot of relevance as to who the significant data fiduciary is and what responsibilities they have. One of those responsibilities now in this changed version of the data protection bill is in relation to children's data. So Trishi, could you tell us in quick 3 minutes as to what your views are in terms of the changes made to data pertaining to minors and children in the JPC report, and what's the road ahead? You're on mute, Trishi.
Yeah, thank you, Argo. Okay, I'm going to specifically touch upon the issue of data protection of minors. Unlike other areas such as government surveillance, etc., where there have been differences between the 2018 draft and the 2019 bill, on this issue, we saw that there was a fair level of consistency in the principle that both the drafts followed, and also the provision that they formulated for protection of data of minors. I think for that matter, even the JPC conforms to the idea that highest protection should be given to the data of minors. But in carrying forward that principle, it sort of reframes Section 16 in a manner that substantially alters it and leads to apprehensions of overregulation. So the basic framework in the 2019 bill is that the authority could designate certain data fiduciaries as guardian data fiduciaries, depending on the services they offered and if they processed large volume of children's data. And these guardian data fiduciaries were barred from certain processing practices, such as profiling, tracking, behavior monitoring, etc. What the JPC does is that it completely removes the entire concept of guardian data fiduciaries. It says that irrespective of whether you qualify these criteria or not, you cannot indulge as a data fiduciary, you cannot indulge in these practices of profiling, tracking, and behavior monitoring of the data of children. I think while this sounds good in principle, it, because you think it provides greater protection to data of minors, it doesn't translate well in practice, because now to determine whether a user is below 18 years of age or not, all data fiduciaries, irrespective of whether they cause harm by underage access to the user, or the kind of potential harm that they could cause to these users, have to put in place age verification and parental consent and control mechanisms. So that design is not proportionate to a risk, is not proportionate to the risk that these minors face, and also it sort of obviates the whole proportionality basis of data collection. I think this sort of improvement is a classic case of overregulation. It leads to compliance concerns for data fiduciaries in terms of what is the duty of care that they have to follow to ensure genuine verification, and also the kind of friction that it will lead to in terms of user interface for all Indian users, because it effectively age gates the entire internet. So I think the problem of overreach it surfaces here. Apart from this, even in section 16.4, there has been a lack of clarity of the scope of processing that is barred, because online service providers are still not clear whether all kinds of profiling, tracking of behavior is barred, or is it limited to harmful profiling and tracking. And this is something that will have significant impact on the design of their services. So they argue that you could potentially have something like session cookies versus cookies that are retained in the system after you log out also. So there could be design solutions to this. I think lastly, just to tie up to what Malvika has already pointed out, there are concerns that have been raised with the threshold of 18 years, while arguing that this might be unduly restrictive of the agency of data of a lot of people. And while the bill empowers the DPA to provide a graded approach, there are capacity constraint issues at the DPA to design this graded approach in a more holistic manner. I think these are the sort of issues that we can, think of. And
thanks very much, Trishi. I think with this issue of children's data, as a few other issues in the JPC report, I feel like the JPC was well-intentioned but poorly advised in some regards. And I think this would be a good segue to Rahul to give us the last word on the Indian law before we turn to Matthias, who will talk about GDPR. So Rahul, in your view, since you're coming up at the end of these opening remarks, what do you think are the key considerations that we should keep in mind between now and when we hope that the data protection bill will become the law of the land?
Thanks, Argo. First of all, my apologies for being late. And as a result, I really don't know whether what I'm going to say has already been said, and I'm going to just sort of wing it a bit. I think, first of all, when I wrote the article about the latest draft, the title of the article was "A Light at the End of the Tunnel." And so as much as we are all, bemoaning all the problems that this current draft still has, we've got to understand that at this point in time, it's perhaps more dangerous not to have a data protection law than to keep trying to perfect this law. In my view, this law is, 80% of this law is excellent. It is world class in many ways. I agree that the remaining 20% in many ways is flawed, and we, perhaps could be dangerously flawed. But we're reaching a point in time where not having a data protection law is more dangerous than trying to perfect it. So that's the first thing that I want to say. I think there is a lot of good that's been added in this draft as well. And so as much as we're pointing to security and overreach and all of those things, there are provisions that have been added which are good. I think a few things that highlight some of the technological innovations that India has made. The consent manager clearly is a hat tip to the DEPA framework, and the DEPA framework, as everyone on this call probably knows, is moving very strongly since September, when the account aggregator was launched. And there's global interest in this sort of a framework, with Australia coming up with its CDR framework as well. So in many ways, we've, when I first looked at data protection, we were very much a pre-GDPR type of formulation. I'm very happy to see that this draft hasn't just stuck to GDPR, but gone a little further than that. What do we need to do now? I think, let's assume that the draft with some modifications will get passed by Parliament. That, as Malvika knows, we've worked on this together, is really the very, very first step. There is so much that has to be done in terms of regulations that have to be passed, standards and protocols that have to be prescribed. The DPA has to lift a very heavy burden. And then I think Matthias will probably give us the GDPR experience, but companies, even companies that are GDPR compliant, will have to do a lot of heavy lifting. We're seeing a lot of our clients coming to us and saying, what do we need to do to get ready? And even though we don't have a law, we, as we're evaluating their systems and processes, we can see that there are huge gaps in compliance with the Indian version of the data protection regulation. That's going to require a lot of work on the part of companies. So from, let's just assume that it gets passed. I think the DPA will come about in maybe 3 months, I hope. So within 3 months, we're going to see a lot more substantive provisions coming out. And in a way, these things have to move in parallel. Many processes can be changed now on the basis of the law. But the moment the DPA starts issuing its clarifications in terms of all the specifics, there will be an increasing number of things that companies will have to do. So for the lawyers on the call, busy times. I hope it's going to be fun. It's always good to be working on a brand new area of law, because in a sense you're co-creating it. And I hope that the regulator is going to be one of those good regulators that will work with us to come up with a regulation, as opposed to sitting from on high and giving dictates. But I'm an optimist. I can't stop being an optimist. I hope that is the way we will go.
Thanks very much, Rahul. Usually a fun time for lawyers means not a fun time for anyone else. But let's see what that experience has been during the GDPR, because we have Matthias. And Matthias, I think we are in India now where Europe was in 2016, early 2016, maybe late 2015, when the GDPR was coming into was going to be readied, and it was that 2-year period before it came into effect. So tell us a little bit about what those 2 years were like in terms of how companies got ready, how citizens got ready and countries got ready for a data protection legislation, and what the 3.5 years since then have been like in 3.5 minutes.
Yeah, thanks very much, Orgo, and thanks also for the invitation to participate in this roundtable. So I think what I can say is we have been there, right? So we have been there, and we are still there, actually. So from a European perspective, and whilst we're still dealing with our own challenges of working with the GDPR, it's always very exciting to see how the global data protection world is shaping currently. And Rahul just said, there's light at the end of the tunnel, and I think we in Europe, we have reached the end of the tunnel. There's some light, but still not everywhere, right? So it's still all work in progress. So yeah, as you mentioned, Orgo, the EU GDPR journey really began in 2016 when it was adopted. Then there was a 2 years transition period for organizations to prepare for these new and much stricter data protection rules. The GDPR then became enforceable in May 2018. So I think we can really kind of structure this into 3 phases. The first phase is the transition period. So the preparation of organizations for the GDPR. The second phase are maybe the first 2 years post-enforcement kickoff date. And the third phase is basically the phase we're in right now. So during the transition period, the first phase, everything kind of began rather slow. But then 12 months before the end of the transition period, suddenly there was this panic. Organization started to worry. There were like these headlines in the newspapers, huge fines, 20 million euros, 4% of global turnover, and so on. So for us lawyers, a very busy time. It was this huge rush. Everyone wanted to be fully compliant, in brackets, something that's really not possible to achieve by 25th May 2018. Data protection policies were drafted, DPOs were appointed, data processing registers were put in place, and so on. The second phase then was from the enforcement kickoff date, the 25th of May 2018. Because then what happened? Not much, right? So companies organizations were wondering what was all this fuss about. There were barely any fines. There was nearly no enforcement, really. But now we're in the third phase, and now it's happening. So the EU data protection authorities have handed out a total of more than 1 billion euros of fines over breaches of the GDPR last year. The biggest fine was actually issued by the Luxembourg Data Protection Authority, which fined Amazon 750 million euros. In Germany, the biggest fine was a fine issued against H&M, the clothing retailer that I'm sure you're all familiar with. They received a fine of 35 million euros. So companies started worrying again, and they start pulling out these data processing registers that they've put in place in this rush before the enforcement kickoff date, and they never looked at it again. And they start updating this again. This is one side of the story. But then the other side, there's a lot of legal uncertainty. I'm sure a lot of you have heard, for example, about these issues of international cross-border data transfers, like the very prominent European Court of Justice decision called Schrems II, which basically said that data that's transferred to the United States is not safe, and you need to put in place appropriate security measures, additional security measures, to make sure that US state authorities cannot simply access the data whenever they want, and so on. And this is a task that was put on companies, which is nearly impossible to achieve, right? Because let's look at the pandemic. Companies needed to use video tools. So we are using Zoom right now. There's Microsoft Teams. So if a lot of my clients are international companies, they need to rely on these tools. But for example, the Berlin Data Protection Authority said you can't use these tools because the data will go to the United States. So there's a lot of challenges we are still facing. Actually, a few of the points that you mentioned before are still challenges that we are still facing with the GDPR. Consent, how to obtain valid consent. That's extremely difficult. What is about damages? Individuals who claim damages, is there like a materiality threshold? When is there really a damage? Privacy by design, privacy by default. So this is again a task for organizations that want to use, for example, the tools of like the big software companies. But the software programs are developed by the software companies. And I mean, let's face it, most companies need to use Microsoft products. So there are a lot of issues that we still have to deal with. So that's why I said it's still work in progress, and it still keeps lawyers, but also IT departments of companies extremely busy. Looking forward to sharing my experience with you when discussing now the developments in India.
Thanks very much, Matthias. I think that sets us up very nicely, and we've done reasonably well for time. And I think first up, we can all agree with the sentiment that Rahul expressed, which is the fact that I think we all agree that let's now get a law, okay? And the fact is that we've been operating in a legal vacuum for a very long time, and we can, as Matthias said, we can improve this law as we go along. It's a long journey, but let's get a law. And if we assume that that's the case, let's discuss. I want to focus this discussion on three issues, which are kind of large looming issues that have kind of crept into each of your presentations. The first is this question of enforcement. Then how do we get from here to a law, and what do we need to do in order to ensure effective enforcement? Part of this has to do with the DPA, but part of it also has to do with companies putting in place mechanisms that allow for this to happen with the thresholds that will satisfy regulators. So number one. Number two is this question on what I call the other things, that is non-personal data and social media intermediaries. Should that be in this bill? And the third is the question of operationalizing consent. How do we make sure that we have in India and in Indian conditions a framework that makes consent meaningful? And if there should be any, as Subhashish rightly pointed out, if consent should be a trump card that companies can play, saying that they are absolved of all legal liability. So let's start with this question of consent. We'll go over to the other ones. We've got half an hour for discussions. If there's anyone who has any questions from the audience, please feel free to type it in the chat box. I'll take as many as possible. So consent, and I'll come to Subhashish because you're not a lawyer, and then to Vyom. The fact is, do you think that consent should be a free pass for companies? Because you left that question hanging, but what is your view on this matter?
Clearly consent is important, right? But I think informed consent will always be a little bit of a myth, even for a computer scientist. I think, so it is impossible to figure out that a particular action or particular application, what are the possible harms that can come to me? And in view of that, it is, I think, a little unrealistic to expect me to be able to assess that completely before I can use that service. That's one. And second, consent often presents a false choice when there is actually none, especially in public service applications. So I think, for example, in health, what do I do if I don't give consent, right? So I may be forced to give consent in some way. So I think that you need a mechanism over and above consent. So there has to be a accountability-based framework that, irrespective of the level of consent, there is a certain standard that the data controller must adhere to, right? And just because you have got consent, you cannot violate that.
I can already see Rahul smiling on hearing the words accountability framework. But before Rahul, I come to you, Vyom, I wanted to get your perspective, because consent is pretty critical on the way in which you operate your banking softwares. So how do you see this proposal that we need more than consent for processing of information?
No, I think I'll go. The point Subhashish made was very important. And actually, I think the 2 or 3 ways to look at consent. One is, when I take consent of a customer, did I make my intention very, very clear and transparent at the time of taking the consent, right? So it shouldn't happen that I'm taking consent from X, but actually my business model is Y, etc. Right? So I think the intent should be very clearly and transparently disclosed to the customer, and then on the basis of that, the customer should give their consent, and of course, consent also has a time frame associated with that. So whether that time frame is 3 months, 6 months, time, etc. Right. So I think that's one important aspect of consent. Now, the other aspect of consent is that, and this probably will be detailed out at the time of the converting into regulation stage, which is more templatized it becomes. Right, more templatized, more, let's say, choose between option A, B, C, D. It becomes with simple English written next to it. It more understandable. The consent is there, right? I gave the example. 90% of Indians just took the vaccine with a very, very nicely informed consent. So I think those are 2 or 3 things which come to mind in terms of making sure that consent is not just free and fair in intention but there's operational design behind it, which makes it very, very fair.
Absolutely. And I think I don't want this to become a general discussion about consent, because I think we can all agree that the principles in the bill are all right as far as consent are concerned. We're just trying to see as to how to make that consent operational. And I think that's Vrinda, you wanted to comment on that? Yes, please.
Yeah, I mean, one of the things I was thinking about that we need to think when we operationalize consent is that one thing that the bill requires is you obviously have to give a lot of notice to the customers, right? About what your practices are, which means the more detailed the notice is, the more difficult it is to understand. So I really think as a good practice, one of the things we'll have is like obviously a longer, proper, like the legal terms of service and the legal consent, but also then putting it in a short, easy to understand, maybe visual manner. And I think good practices would sort of start seeing companies do both. And I think the other thing to really focus on is also like the use of visual, like so dark patterns and, like things like images and how you present different options and, what option you highlight and what option you don't. I think those are also just in general things that companies will kind of need to start thinking about. And then also like things like another good practice I feel is like this at the time of moment consent, right? So when you try and use something on the iPhone, do you really want to use your camera? Like if you put no, you can change the settings at that point of time and change it back. So I think also having like granularity and like the ease with which you can change your settings is also something that's important. Of course, that will not work in like maybe a financial banking sector. It's easier in like a social media or an app kind of system. But I think these are also other considerations.
So Rahul, very quickly.
Trishi's got a hand up, but I just wanted to jump in because I just felt like everyone is talking to me, both Vrinda as well as Subhashish. And so, I don't want to harp on accountability. I know Justice Sri Krishna considered the accountability framework that I proposed and said we are not ready for it. Hopefully that was 2018, and now in 2022, we are ready for the accountability framework. And we certainly have to consider that. But, like what Vrinda says, I think we've got a number of tools. No one's saying that consent is not okay. No one is saying that consent can be perfectly provided. But we have a number of tools, and we've got to optimize those tools in where they are necessary. So a lot of the things that Vrinda said, granular just-in-time consent, absolutely powerful in a particular context, because if you're doing granular just-in-time consent when you're processing financial information in order to provide a loan, it makes sense. It doesn't make sense when you're being served an advertisement, because can you imagine if you're being pinged just in time when your website has 20 advertisements on it? That would be just death by 1,000 cuts. So we have to use the correct tool in the correct way. Once again, as Subhashish and Vyom both said, consent is absolutely important. And I think my accountability framework was misunderstood in many ways. To believe that I said that consent is not required. Yes, I did. I mean, in many places I said consent is broken and all of those things, but you can't take my data without my consent. I never intended that. What I mean is that if you're using consent as the mechanism, a get out of jail free card, that can no longer be acceptable. And so that's why I think there is a common thread through all the solutions that people are mentioning. I'm just urging that we don't use them all. We use them in the appropriate time. And just one last thing, because Vrinda mentioned it, Vrinda actually harped on Helen Nissenbaum's transparency paradox, which is essentially that it is paradoxical on the one hand to say that you want to have all the information that is necessary to make informed choice, because all the information is so complex that no human being can understand it. And then you say you must simplify it, but then if you simplify it, you don't have enough information to make an informed choice consent. That's the transparency paradox. That's fundamental to our modern world of data management.
That's right. And I think the question that keeps striking me is, how are we going to make consent work? And I think that gets us to this enforcement question. But very quickly, Trishi, just very quickly on this point, because we really must move on, but quickly.
So on this point of consent, I think especially for children's data, this becomes particularly important. And UK ICO has put out an age appropriate code, so what it does is it says that parental consent is not required for people above 13, between 13 to 18, but anyone under 18 is still considered a child. So persons between 13 to 18 still have to give consent as children. And it lays down a very good framework for consent. And I think that is something which above 18 people can also sort of like inculcate in terms of giving consent in the kind of manner of the way in which those terms have to be communicated to them, the just-in-time notifications that we're talking about, the opt-in systems for all privacy sort of invading techniques of data fiduciaries. So I think that is something worthwhile to look at.
So thanks very much, Trishi. I think that's something that we should definitely look at, because in some sense we all feel that we are all digital children at the mercy of some mercenary adults. But I think that the question that we can go to is one of enforcement, which is that how do we operationalize consent? And more generally, what do we do from now to when a law gets passed? And the question here must come to the DPA. And Malvika, I'll come to you. Is that we're now talking about a DPA. We'll hopefully have a DPA in the first few months of the law, after the law being enacted. Where are we going to get these people from? Even if it's, let's assume it's going to be 6 whole-time members. Let's say we're not going to make a change as far as this is concerned. We're not going to make a change as far as the selection committee is concerned. Let's assume all that is fine. But we know that under enforcement is a major problem in government. Like we have the IT Act, which has been around for 20 years, as it's severely under enforced legislation. So where are these magical folks going to turn up from? And what are these systems that are going to be designed? And in that context, I'll take a question from Lalit Panda, which I think is stating this very well. And he says that has always seemed like any actual enforcement of a data protection law requires technological mechanisms of the kind as to how the data has been used. And given the fact that these are not there, how reliant is data protection enforcement on cyber forensics? So both a question of technological processes for enforcement as well as manpower. Malvika?
Thank you, and I hope you can hear me now.
Yeah.
I think just to answer your question straight off, I do believe that there's a need to leverage technology, and this idea of technically enacted accountability is becoming even more and more important in many countries that are going through the similar transition, right? And on that front, what do I mean, to answer Lalit's question as well, by technically enacted accountability? It means that the few people that you have need to fundamentally shift the way that they're thinking about regulation from a top-down model to something called polycentric governance. And I think this is something that many people are experimenting with, is that when you have so many, in a complex system, when you have so many different conflicts happening all the time with a need for enforcement, there's no way that an office in Delhi is going to be able to address all of them. Not in India as we know it now, definitely not in the virtual kind of landscape. And practically, what do I mean by polycentric governance? That means on the one hand, at the design level, the regulator needs to be thinking about how do you design these interfaces between people so that, for instance, there are no dark patterns when you're taking consent. So there is some design level enforcement, ex post or ex ante, enforcement that you can do. But I really think the interesting and fun and exciting thing is going to happen when you're actually enforcing at the point when technology is acting. To give an example, Apple in a couple of months ago changed the way that their app tracking was happening. I think this was last year. And that, I would say, was the single biggest kind of enforcement mechanism that a non-state actor did when it came to data protection. It had serious economic consequences as well. Many would say that they were actually trying to kind of using it as an economic strategy. But I think it's things like that, where are the governance mechanisms, not necessarily as we know them now, which is a fine or an investigation, but what are the technically enacted accountability mechanisms that we can start thinking about and that regulators can start thinking about, because we need to crowd in help if we want enforcement.
Subhashish, can you throw some light on any technically enacted, if I've got this right, accountability standards that perhaps can be designed?
It's not so much, I think, technically driven standard that you require, but I think that you require to specify certain standards. So when you say, for example, DPA will specify standards for purpose limitation, how will you specify? So any digitization that you put in, there is a certain basic risk of privacy. You cannot have a zero risk privacy digitization public service application. Now, how do you model the minimal privacy risk that an ideal application would suffer from? Given that you have perfect security, you have perfect technology, what is the minimal privacy risk that is entailed by that application? How is that modeled? And unless you discuss those terms and unless you lay standards for those terms, I think you can never come to a proportionality test. You've not even modeled the privacy risk. So how do you balance the utility versus the risk in a correct way? So I foresee that, with this gap remaining in the Data Protection Act, people will interpret or different DPAs or the DPA. There is no predicting how the DPA will interpret the standard and set the standard. And probably we will have to go through, as Rahul said, a long period of time to understand these issues, and they will materialize. But I think that the discussions should start about, what is the standard for purpose limitation? What minimal due diligence is acceptable? So, for example, I'll give you an example of this. So in the NDHM, they're saying that there is privacy by design because the data is at the source. There's no centralization, and that is privacy by design. Now, how is that true? Right? By what principle? Right? Is that statement even acceptable? So, how do you evaluate such a claim? Right? And so we have seen such claims in Aadhaar. We have seen such claims in almost everything. Right? And different people will come and say different things. Somebody will say that I've implemented privacy by design. Somebody will say, no, you haven't. And I think that settling in court is probably not the best way to deal with this situation.
That's right.
So we should probably have to work towards defining standards.
Right. And I think a thought that strikes me is like with the GDPR, there were these wonderful papers produced by the Article 29 working group. I think perhaps an interdisciplinary group like ourselves should call ourselves the 7 p.m. working group and start having these discussions on what these standards might be, just in order to foster a greater discussion on this issue. But I'll bring in Supratim on this question on the DPA, especially given the fact that the DPA is, as Matthias said, as it is critical to any seriousness of enforcement is what the DPA is doing. So how do you see this question of the DPA being set up, who mans the DPA, and the powers that the DPA has in order to make this data protection bill have teeth?
Right, I'll keep it very short, Argo. The way I'm observing it, and we have been deliberating this right from the beginning of crafting of the law, that there is too much at the hands of this DPA. Okay, one thought process which is also brewing right now is, do we need them at the state level also? So maybe all of us can put in some thoughts around that as well. It would be a challenging task, and given the overall timeline, etc. But ultimately, I think we would need more manpower, resource, and
genuine effort being put in order to really get this operationalized. So I think that's a great thought as of state level DPAs, and I think I'll come to Matthias with that, especially because of the fact that we forget that in Europe it's not one DPA, right? As in it's the data protection authorities in various countries who are doing their own things. And I wanted to ask you, Matthias, as to how that experience has been, because I'm guessing that I don't know, a DPA in Berlin would be very different from a DPA in Luxembourg, or possibly might be different, and we're not even talking about Southern Europe yet. So one, how different has it been with working with different DPAs? And the second, which I think is a very interesting audience question from Shubham Bhattacharya, who asks that in the Schrems 2 decision, as in the Privacy Shield failed to meet the adequacy requirements put forth by the GDPR, and he's asking whether you think that given the extent that the present Indian Data Protection Bill, it does give a carte blanche to the government to exempt any agency from the provisions of this act. And I'm just making this simple because you may not have read the whole of 35 and 36. But given the fact that it allows the government to exempt any agency from all or any of the provisions of the act, then do you think that that might also fail the Schrems 2 test? So 2 questions for you.
Yeah, great. Thanks very much. And I start with the state level point, because not only do we have data protection authorities across all of the EU member states, but in Germany itself, because of our federal system, in each federal state, we have a separate data protection authority. And of course, on the one side, this leads to kind of different opinions and different guidelines and so on, which makes it sometimes a bit tricky for companies to deal with this, in particular, if they operate across all EU member states or within Germany or all across the whole state of Germany. But I personally think it's a much better system to ensure enforcement, because you will have pressure. And we see this at the moment in the EU with Ireland. So all of these big IT companies, they sit in Ireland, right? And the other EU data protection authorities say, you guys in Ireland, you're not doing enough, because you want to keep these companies, right, in Ireland, and you're not enforcing properly, and so on. That's one side of the story. Of course, Ireland says we are doing enough, we have to investigate. But what I wanted to say is, there is some kind of pressure. There's a competitive element in there, which is anyway the underlying basis of a federal system. And this is exactly what we have in Germany. We have a few data protection authorities who are very active, provide a lot of guidance, who are focused on companies and their needs. We have others who are different, and this balance is each other out. And I think this way also is a way to ensure more enforcement. Yeah. So this is my answer to the first question. The second question, Schrems 2, of course, that's a political point, really, right? But if the situation is as such that Indian state authorities can simply access data of EU residents without EU residents having the possibility to take this to court to defend themselves in India, without perhaps a US authority having to address the court themselves before they access the data and so on. If these mechanisms are not put in place, I think it is very unlikely that the European Union will grant an adequacy decision to India, or unlikely that, for example, mechanisms like the standard contractual clauses will be sufficient. So we need to see. In the end, really, this is kind of a political item, really, right? That needs to be assessed from that side as well. And maybe one comment about this, Orgo, last comment. The European Union, the European Commission, and the United States are currently in talks. Maybe let's call it EU Privacy Shield 2 or Safe Harbor 3, right? It doesn't matter. So it's likely that we'll have another transfer mechanism very soon with the US, and then perhaps again it will be challenged in court. Because in the end, if you think about it, I don't think any state will change its surveillance law because the European Union says, hey, we can't transfer freely the data to you, right? So that's also something I think to keep in mind. Yeah.
No, I think that's a very valid point. I don't think the surveillance law is going to change because the EU is going to put pressure. It might be different with some other countries, but the adequacy requirement is a political issue, and I don't think it's a legal issue. It never has been. But Rahul, before I turn to the third set of issues around these other things on non-personal data and social media intermediaries, on the question of enforcement, and Amin has asked this as well, and this is a theme that's there in the data protection bill, and we're wondering about how we can bolster this, which is on data audits and data auditors. As in, how can we try and think about empowered data protection officers within companies who can take calls and also effective data enforcement audit without creating too much compliance? Rahul.
Yeah, look, I mean, I think once this goes down to the tools, right? Audit is a tool. And if we can take as much of the burden off the DPA and as much of the burden off the actual processes of the regulator in an efficient way, we should do it. What do I think audits are? Ultimately, if you can do a data audit on your processes, you are actually certifying that, at least from a process perspective, and individual practice might differ, circumstances might differ, but generally speaking, the processes are going to be privacy preserving. We've tried this mechanism, these sorts of approaches in numerous sectors. We do it all the time in the company, in the corporate sector. We do it in highly places where it could have a life and death implication, like in the airline sector. You would do it in the health sector. And so this process of, in a sense, delegating, but delegating through a third-party auditor, compliance with the regulation is tried and tested and is something that we should absolutely do. I think the devil is in the detail, of course. And once again, take the aviation example. The regulator needs to be completely in control of this audit process. Otherwise, you'll have the Boeing 777 MAX or whatever, where the aircraft was so complicated that the FAA gave the responsibility of making the regulations to Boeing itself, who obviously overlooked some things, and many planes fell out of the sky. And we can't have that situation happen. So I do want to voice that caution that we can't leave everything to audits, but at the same time, audits are very powerful tools. And I think we're going to be hit by a truck the moment the data protection law comes in, not just the data regulator, but every single one of us. Because you all remember what happened when GDPR came into force. We were inundated with messages, emails from our European friends saying, please accept these new terms because otherwise I can't let you see my website, or just ridiculous things. We're going to be hit with a ton of those sorts of things, right out of the starting gate. And any tool that we can use to minimize that is something that we must grab with both hands and use.
So I think that's a great point, and we'll segue into our third bucket of discussion, which is these other things, particularly non-personal data. And there is as Supratim rightly pointed out in his overview, there's been a trend of thought that we have this legislation as some kind of omnibus legislation, including non-personal data. And Vyom, as a bank which deals with large amounts of personal data as well as non-personal data, how do you see this recommendation of trying to get non-personal data in some shape or form within the personal data universe? And how do you see the way forward as far as this issue is concerned?
So that's a very interesting one, Argo. I think what we were discussing a while back was, some sort of technology controls around, how data is managed, etc., can really help the cause of audit and the controls part. I'll just add one more point to that, which is, it is a mix of technology plus ensuring that the right documentation is in place in the organization. But coming to the non-personal data side of things, I think it is, in simple terms, A plus A complement, right? So it's the universe. So if you add personal plus non-personal data, it's the entire universe of data which is held and maintained. So really there, the one is talking about really the entire data center security, or one is talking about the entire security architecture, which is of course a far more technical domain. But I think the draft bill also talks about end using computing architecture to be certified, etc. So I think that sort of starts going in that direction of IT security, infosec controls, etc., which I think is a great step. Anyways, in areas which are not so tightly regulated or lightly regulated. I'll add one thing to that though, which is I think one need more clarity in terms of what does a sandbox really mean, right? Sandbox, we were discussing terms which are sort of lightly defined, right? And sandbox also happens to be one of them, right? Because clearly non-personal data holds a lot of value for organizations. So think about the actuarial models that insurance companies might be running, right? Or let's say location models that the cab companies might be running. So there's a lot of IP in non-personal data, which is fundamental to the existence of the firm. So we need to ensure that through the process that is also protected.
No, I think that's a great point, and it's really the universe that you're talking about. And Brinda, I'll take this to you, and there's a question from Vidushi Sinha as well, which is that doesn't the inclusion of non-personal data lead to the overall dilution of the objective of the PDP, given the fact that it was about privacy and it came out of the Puttaswamy judgment and Aadhaar? So how do you see this question of non-personal data in this bill?
I mean, I think, like probably everybody who said it here, is that yes, we probably need to regulate non-personal data, but I don't think the Data Protection Act is the right way to do it. Partly also because there's been not a lot of thinking around it, right? So we saw this as just something the JPC has done, something as complex as including non-personal data, the implications, whether it's an IP implication, or even if you see there are mistakes in the bill in terms of reporting, data breaches. So they talk about reporting a data breach, but then really they don't make important changes when they say the DPA will decide on personal data breaches. So, I mean, for all of those reasons, I think this is probably too fast. It's done in a way that I think there are going to be a lot of unintended consequences. And given all the concerns you've already spoken about in terms of enforcement, lumping another set of NPD issues, and they are not always the same. I think personal data protection issues are actually slightly different from some of the issues, like in terms of the specialization, you would need to understand the IP issues and general intellectual property when it comes to non-personal data. So to expect 6 members to have that same breadth of knowledge also, I don't think is fair. And yeah, I think, like you said, because it came out of that Puttaswamy journey, I think it would have been nice to sort of front and center personal data, especially given that you see the JPC has also added things like, security, sovereignty being one of the important parts, objectives of the bill, and digitization and digital economy. So I just think it would have been better to separate them.
Right. Trishi, you wanted to comment on that?
Yeah, I just had a small comment. I think the JPC is also probably misguided because one of the comments it makes while asking for inclusion of NPD in this framework is that it says all NPD stems from personal data, which I think is a very limited way of looking at non-personal data, and maybe one of the motivations of including non-personal data, right? So they're just looking at the whole anonymization aspect and bringing it in, but I think it goes beyond that also.
That's right. And I see, Supratim, you're nodding your head very vigorously. But one of these other things also is in relation to social media intermediaries. And that's at least somewhere where we can say that it's personal data. And the committee can rightly say that this is personal data. And when people think about privacy, people really do think a lot about social media intermediaries. And I think there is a very intuitive justification for the committee wanting to include social media intermediaries front and center into this bill. But what do you say to that, given the fact that you said that it belongs somewhere else? Could you elaborate a little bit as to why you think social media intermediaries perhaps should not belong in this data protection bill as a separate category?
Right. Thank you, Argo. So I think when we set sailing, Argo, we had data protection as is really the requirement, and the ground norm was supposed to be laid in relation to that, not granular issues as they come up along the way, right? So we have a situation right now where you can clearly see from the report the bitterness that is there against the social media intermediaries. It's very openly written, okay? And all of that has come up, to my mind, also neglecting what is happening. Perhaps, I don't know at what point of time they would have written it, but all that is happening in the Information Technology Act, the intermediaries rules, the FAQs that were released, to my mind, those have not been taken into consideration. The fundamental question, whether it should be there or should not, to my mind, it should not be there, okay? Because this law is supposed to be an umbrella legislation for data protection. Granular issues or requirements would be there. There is definitely issues around, social media intermediary, but that does not mean you keep parking it at, different places or have multiple legislations talking about the same thing. In fact, there are blatant errors when they have copy pasted or moved around things here. So if you see the definition, there were certain exceptions which were there. Now, the report per se does not talk about removing of the exceptions, which are for, say, social media intermediaries does not include businesses, okay, or say enterprise solutions, etc., should have been sort of parked out of it. It has got it, the point made in the report is only about movement, but when they have moved it, they have removed the exception part of it. This has already created an issue in the intermediaries rules. They had to come up with an FAQ to sort of color it by saying we are not changing the law, but telling you how you should look at it, okay? We are only talking about something, maybe where you can make a content viral, or, strangers can meet with each other, things like those. So I'm saying, why are we going down the same route, okay? And also, definitely, this is not the place to park this kind of, provision.
I think that's a very compelling argument that we need something on social media intermediaries, certainly, and they are covered because they are data fiduciaries and significant data fiduciaries, but any specific regulation for them should be separate. And I think that's a good segue. I'll take two more audience questions and then we'll close, but that's a good segue to take the question from Bhavna Murlidhar, who asks how the PDP bill will fit into the sectoral approach to data privacy regulation, given the fact that various sectors will come up with their own rules. And say in the banking sector, the RBI has come up already with several rules regarding the governance of data. So I wanted to take that first to Matthias in terms of how the GDPR has done this and how it interacts with various sector-specific regulations, say in banking or insurance and so on. Matthias, do you have any thoughts on that?
Yeah, absolutely. I mean, I think this is exactly the nature of things, right? So as Supratim rightly said, we have a framework for the protection of personal data, but then we need special rules with regard to certain sectors. Actually, at the moment, something is happening in Europe is in the field of AI, right? There's a draft AI regulation because we feel, hey, when we talk about artificial intelligence, maybe the GDPR itself is not sufficient. We need to go a bit broader. When we talk about social media, we talk also a lot about hate speech, right? Okay, but hate speech, again, is a specific area that can be covered or should be covered by a separate law. Because, again, what is the objective of the GDPR, or perhaps then the Personal Data Protection Bill, right?
So
The objective is.
I'll turn to you.
Sorry, was the connection, was it gone? Can you hear me?
Sorry about that, Matthias. Please continue.
Yeah. What is the objective? The objective is to protect personal data. So yes, absolutely. In Europe, we have then laws. We have criminal laws that cover certain type of data, for example, for lawyers and so on. I think this is required because you can't cover everything in one law. That's simply not possible. It will lead to confusion, and it will actually make the law less effective in the end. That's my view on this.
Yeah, sorry about that little interruption, Matthias. I just
no worries.
I wanted to make sure that Justice Sri Krishna has the last word, so I was getting you.
Right.
Rahul, do you have a thought on the sectoral regulation working side by side with kind of a horizontal legislation of this nature?
Yeah, look, I mean, I don't disagree with anything that Matthias said. I think this is really the way to do it. In its design, this is a principle-based legislation, which means that the legislation talks about the basic principles. Those principles get cascaded down in the various sectors. So you follow the same principle, but you apply it specifically in the sector. I wanted to highlight actually another tension that we've already seen develop. And that is how this is going to play with other regulators and strong regulators, like, for instance, the Reserve Bank of India. The Reserve Bank of India has already issued privacy-related regulations. They are going to need, at least in some instances, to amend those regulations to bring it in conformity with the new provisions of the Data Protection Bill. We've already seen the Competition Commission of India issue a paper to say that privacy is a non-price. I'm not a competition lawyer, but it has a non-price impact on competition. And so the Competition Commission believes that it too can regulate principles relating to privacy. These are, I can see Matthias nodding, these are issues that are being discussed by regulators around the world. But our regulators, I'm sorry to say, don't really have a great track record of working together and coming to a solution. Instead, one regulator comes up with a particular view, the other regulator could come up with something which is completely different, and then it's us that are left in the middle trying to figure out which one we have to comply with. And I know that the data protection regulation actually has a provision which says that we've got to find some kind of common understanding between the regulators, but that's easier said than done. So how are we going to implement that? I think that is a really important next step in this sectoral implementation of the data protection regulation.
Thanks, Rahul. And I think we'll take one last question from Anupam Khanna. And Shubhashish, I think perhaps you're best placed to answer this as to whether the trend towards edge computing make technology, will that make technology enacted accountability easier or more problematic?
I don't think that there can be anything called technology enacted accountability. I think accountability has to be human, right? Fundamentally, technology can help, and technology cannot do anything unless you define things properly. And human beings will have to define things correctly, be it edge computing or be it anything else.
Right. Yeah, Malvika, do you want to comment on that?
Yeah, sure. I guess, yeah, that when you use the word technology, everybody seems to think the tech will solve it. And so maybe I said a cat among the pigeons, but just to clarify, I think, the entire idea is that, any regulation is socio-technical. And the question is, the thing that we always say, can human beings or can law fix what technology is broken? And I think the question here is, how do we make that technology more accountable? Simply thinking about enforcement in a vacuum, as in going to that bad person over there who used Twitter wrong and then putting them in jail, is a little bit of an old school way of thinking about it. We're going to have to think carefully about, how do we design and enforce these systems themselves? Because fundamentally, I think this takes me back to the just a reflection to the original question you started with, Orgo, which is about consent. Consent is a necessary but insufficient condition for all of this to work. Beyond consent, what you need is a structure that is more fair. And that structure can only be fair if the technology is built with a certain level of accountability. So my response is yes, I think that actually monitoring the design and enforcement of the technology and the structure itself is going to be a larger and larger part of any regulator, which is, a little bit of a departure from how we've thought about data protection necessarily in the past.
Correct. So I think from the roundtable, if I were to attempt succinct 3 points that we've got out of this, first is that, as Rahul has said, we need a law. We need that light at the end of the tunnel. The tunnel's long enough, and we need that law. Second, we need to focus on data protection and personal data protection. We need to leave the other stuff out of it. It's not that it's not important, it's just that this is not the place for them. And third, we need to start developing the codes of practice, the standards, the regulations that ought to be coming up, which actually give meat to concepts such as consent right away. And I don't think we need to wait till the law comes and the DPA comes, and perhaps we can think of forums in which that can be done, which can provide assistance to the regulatory authorities once that's done. So I think that summarizes the session so far, the 1 hour 25 minutes. But as I said right at the beginning, we're delighted that Justice Sri Krishna is here with us today. And given the fact that he's really started off this journey in India, it's only appropriate that even though the journey is not over, our journey with the webinar finishes with him. So Justice Sri Krishna, how do you see this bill at this stage from the time you drafted it yourself in 2018? And how do you think we can take this over the line?
Argo, I've always maintained, I think I think it was Malavika also who, and Vrinda also echoed my thoughts, that all law is directed towards the human beings whom it must impinge upon. Law is not in the air. Law is not meant for regulators. Regulators are meant for human beings. How are you going to control their behavior? Now, the problem with this is you had a whole exercise of PDP of 2018 vintage was, how do you protect the fundamental right which has been now declared to be the right of privacy, which has now been declared to be a fundamental right? Now, that was the exercise that was being carried out, being done. Now you have added something to it, and it's something like, I don't know, I'm not a non-vegetarian, but do fish and fowl get cooked simultaneously? I'm not sure, because I have no idea whether it gets cooked or not. But I think it's a matter of mixing fish and fowl. And the whole idea seems to be that anyway, something was going on, let's bung it also into this and see how much of it can be done. The issue will be, there will be a whole set of data which will be covered by the fundamental rights, a whole set of data which is not covered, and a whole set of data which is intertwined. I don't know how you're going to do all the separations that you're thinking of, and how the high technological solutions that you are really breaking your head. Are they going to separate the grain from the chaff? I doubt very much. So we'll come across to a situation where, as the old ancient Indian Ardhajarati Nyaya Dimamansika said, that you take an egg and say, half of it I'll boil and eat, half of it I'll use for hatching. That is precisely what is going to happen. And you will end up with having nothing. And I started by saying this. You wanted me to say what the journey has brought so far. I would say another popular quote which I have already articulated, saying that Vinayakam Prakurbano Rachayamasa Vanaram. You start by saying that I'm going to make a Ganpati, and then ultimately you find that you have made a monkey. And that is precisely my thinking is out of it. That's the last word that I have to say.
Well, it's always amazing to hear from you, Justice Sri Krishna, as it is always amazing to hear a Sanskrit quote to end off a data protection meeting. Maybe that's what's going to be original about the Indian data protection law. But thank you very much for that comment. And thank you to all the panelists on the roundtable for joining us for a really enriching discussion. We hope that it's the beginning of many. And thank you to all the members of the audience for being part of this and for following our work, as well as asking questions. I hope all of you have a good and safe evening and days ahead. Thanks very much. Good night.
Thank you. Thank you.
Thank you.
Thanks, everyone.